therefore my humble prayer, my Lord, that they are all found to be substantial, and my Lord, in keeping in line with the ruling that I earlier referred to, Miscellaneous Application 113, 2015. My Lord, that is it.
For the record, I'm Jatiko Thomas.
Another state proceed.
They have been there for 3 hours.
We have
been there for 3 hours.
One can proceed if Jatiko wants to. Let us proceed.
Chief Secretary.
This is the council.
Richard Lee from Local Chief Secretary.
Chief Secretary.
Yes, my Lord. My Lord, as respondents, we are working as a group, as a team. And there's some information, my Lord, which was brought here where we are in court. For example, in respect to the sureties, for which as a team, not as a single prosecutor, we need to deliberate upon before we become presentation. The sureties and some
The sureties you reply later, but proceed.
my Lord, this will be here and that we seek a standover of 30 minutes to proceed, to be able to proceed. And it is a submission that we ask for 30 minutes to prepare and
It is my considered view and opinion that we proceed. There are 3 state attorneys in court. Let us proceed. Where you have reservation, point it out. In respect of the sureties. Where you have reservations. Let us proceed. Where there are some things unique to education, we shall reiterate.
my Lord, we have an option to proceed. My Lord, I will take the presentation for the respondent. Lord, this application is primarily based on the activity that the applicant, before you, locked mandatory period before they are committed to High Court. And as such, they should be released. My Lord, the applicants also raised other issues, other grounds like advanced age, sureties, among others. The respondent shall also make an omnibus response to the two applicants. This application is solely hinged on whether or not the applicants had brought mandatory and whether court can go ahead and admit them to bail. Premise on the prayer on the above, my Lord. My Lord, whether or not the applicants are declared mandatory, it is a submission that by the time of committal, on the 29th of May 2025, the applicants had not blocked mandatory. In fact, by the time of filing this application, my Lord, which is the 29th of May 2025, the applicants had already spent 98 days on remand. Days on remand. Yes, my Lord. My Lord, we refer you to paragraph 15 of the affidavit of Detective I.T. conducted Kizza Besigye in respect to the first applicant, and paragraph 12 of Detective Inspector of Police conducted Kizza Besigye in respect to the second applicant. My Lord, the applicant we are remanded in custody on the 21st of February 2025. And that was the time when the Office of the Director of Public Prosecutions had taken over or had instituted fresh investigations and therefore brought fresh charges against the applicants. My Lord, the applicants were charged with on the 21st of February 1925. They were charged with treason and misprision of treason. My Lord, it is not true. It is not true, therefore, that the DPP was in charge of this matter, of the applicant's matter, while they appeared before the General Court Martial on the 20th of November 2024. Much as we acknowledge the office of the DPP is provided for under Article 120 of the Constitution. And under Clause 3B of the same article, the office of the DPP has no jurisdiction over matters that emanate from the General Court Martial. These are two different institutions. Whereas the DPP is under the Constitution, the General Court Martial is a child of the Uganda People's Defense Act. In fact, it is an absurdity to hear the applicants argue that the office of the DPP had jurisdiction over the charges that the applicants were facing before the General Court Martial. The charges in the two were completely different. The charges in the two were completely different. The respondent shall not repeat what the applicants stated about the charges against them before the General Court Martial. But we shall simply emphasize that those charges which they were facing before the General Court Martial are completely different from those that the applicants are right now facing. My Lord, would refer you to the case of your brother, Honorable Justice Dr. Douglas Kizza, while handling Civil Division Business Cause number 31 of 2025. Number 31 of 2025. As the applicants, we are seeking the right of habeas corpus. My Lord, I just want to go through this briefly. Just right from the argument. A copy of the set is here and we are about to highlight it. That is retired Colonel Dr. Kizza Besigye and of dead retired versus Attorney General and Commissioner General of Prisons. Those are the patterns. My Lord, my senior colleague, Honorable Redax Sephora, as he is, submitted as below. That the transfer, that is true, the transfer of the General Court Martial files to the DPP and the civil courts is legally impossible. Since that court had no power to try the applicants in the first place. Just for emphasis, my Lord, what you about here, my Lord, is my submission. Is that the rationale of that is that whereas the UPDF and the General Court Martial fall under the military justice system, the civil courts fall under the civil justice system. Bundling the two would be a legal error. As if that's not enough, my Lord, my colleague, my senior colleague, Honorable Redax Sephora, is continuing that the Supreme Court did not order. He's going to submit that the Supreme Court did not order the DPP to take over the GCM files, General Court Martial files. Because doing so would infringe the constitutional provisions in brackets under prosecutorial powers of the DPP. That view was also echoed by Vice Chancellor Lord Mayor Elias Yukon, Council for the Applicants. Now, in that application, may not allow me both directly and both verbally what the judge had to say. He said that, as understood by this court, the applicant's position is that to the extent, remember this is on page 10, that to the extent that a Supreme Court decision nullified the power of the General Court Martial, GCM, to try them, they remain in illegal detention. Because they are no longer lawfully detained by the prison authorities. And yeah, that no longer lawfully detained by the prison authorities, and cannot remain in illegal detention. On account of the uncertain administrative processes that seek to implement the Supreme Court's decision. Besides, all previous cases before the GCM, General Court Martial, had equally lapsed. And it could never be resurrected by the DPP. Because, my lord, this is very interesting. Because doing so would be constitutionally improper. He further stated that under Section 56 of the Evidence Act, Cap 8, yeah, Section 56 of the Evidence Act, Cap 8, this court is enjoined to take judicial notice of the proceedings of 21st February 2025, in the Chief Magistrate's Court of Nakawa at Nakawa, in criminal case number 285 of 2025, in which the applicants were formally charged in the courts of law and remanded. while the court would have wished to answer the issues raised, while the court would have wished to answer the issues raised, it would be moot for it to do so. The application was dismissed. My Lord, these were the arguments of the applicants in that application. It shouldn't be them right now having spoken English in the other application, then they speak Chinese in this one. What do I mean? To change goalposts and then submit that there was a transfer of the cases from the General Court Martial to the Office of the Director of Prosecution and the Judiciary. By arguing so, there will be a possibility of actually misleading us. It is an improper interpretation of Article 120 of the Constitution in terms of the roles and then the jurisdiction of the court martial. My Lord, I appreciate the fact that this ruling, my Lord, is persuasive. However, we invite you, my Lord, to take judicial notice of that and agree with that as the proposition of the law. If you, my Lord, agree with the respondent that that is the proper position of the law, then the argument by the applicants, my Lord, lacks merit. It is misplaced, and it is irrational in one way or the other. And if, my Lord, you agree with the respondent that that is the position of the law, then it means that by the time the applicants were committed to High Court, or by the time of this filing of this application, the applicants had not, as alleged, spent over 180 days in custody, but in fact, 88 days in detention. I hope I'm safe. You can hear. I pray that God guarantees my security. Our security behind there.
Everyone is safe.
That is evident, my lord. The court takes note. We pray that court takes note of that kind of behavior, my lord, of jeering. We don't have it on record that the public was jeering at the prosecutor. Yes. Most of that, my lord. My lord, the trial, the presiding magistrates who handled this matter right from the 21st of February 2025 do not have the record. There is no record before the magistrate or judicial or courts, civil courts. Of the proceedings before the general court martial. And my lord, the applicants have not provided evidence of that record before this court. And if it has not been provided, my lord, in any of the court record at Nakawa, then that speaks volumes. It is only emphasizing the argument by Yolandi brother in the miscellaneous application, miscellaneous cause number 31 of 2025. Meaning that the civil courts have no control. And there was no transfer. And therefore, what will be the basis of the magistrate who was actually so, my lord, we implore you to agree with us in that regard. My lord, on the day of committal, on the 29th of May 2025, it was submitted by defense or the applicants, my lord. That the applicants were committed in the absence of their counsel. My lord, it is not true that the applicants were committed in the absence of their counsel. They are on record on 29th of May 2025 representing the applicants before Nakawa Chief Magistrates Court. They only, my lord, out of protest, ran out of court. They went out of court, my lord, and the court had nothing to do but proceed with the commission. And that was the second time, my lord. It also happened on the 26th of May, 2025. My lord, therefore, if this court is alert to that fact, then would have responded that the committals, or this application was overtaken by events. My lord, the counsel for the applicants argued and actually submitted so many authorities which we shall not actually repeat. arguing that this bail, the mandatory bail, that applicants are actually clocked mandatory bail, and therefore this court has no options but to simply release the applicants on bail. Yeah, sovereign authorities, my lord. Even if the applicants, my lord, by the time of committal, that is on 29th of May 2025, had clocked mandatory, the applicants cannot benefit from mandatory bail. The applicants are misinterpreting Article 23(6)(c) of the Constitution. And it has also been misinterpreted. And with all due respect to the authorities that have been provided, there has been a misinterpretation of Article 3(6)(c). 23(6)(c). Reason that it only applies only if by the time an accused person appears before High Court while applying for mandatory, he or she has not been committed to High Court. The ruling which the applicants relied upon was reached in the petitions where the applicants had not been committed to High Court. And those are only cases, my lord, where this court is bound. The applicants in those cases had not been committed to High Court. The other cases, my lord, which have been cited, my lord, from the High Court, my lord, with all due respect, there was a misinterpretation and misapplication of Article 23(6)(c). And since the Supreme Court cases cited by the applicants, since there is a difference between the Supreme Court authorities provided by the applicants before you, my lord, and the High Court cases, my lord, which we shall not repeat, we agree, my lord, with my senior colleague, Lord Mayor Elias Lukwago, that you can take a different direction. Because you're not bound by the judgments of High Court. Actually, it would be also, my lord, a misinterpretation of Article 126(2)(e). Because then, if the applicant or the accused person has been committed to high court, what is substantive justice that is at stake? That is trial of the accused person, not bail. We therefore invite you, my Lord, to interpret Article, to apply Article 23(6)(c) in a proper way. Because the applicants, that is on assumption, my Lord, that you disagree with the respondent and agree with the applicants that indeed by the time of committal they had blocked mandatory. That is if, of course, that's not our submission. But if you are inclined to believe that by the time of committal the applicants had blocked mandatory, we submit, my Lord, that you interpret Article 23(6)(c) objectively. My Lord, that would mean, my Lord, just to emphasize that point, that if you interpret it like your brothers and sisters did, it would mean that the most critical thing is not the trial, but the bail. But these criminal matters have different stakeholders. They have victims, they have the public, and therefore it is a submission that what would be at stake at that material point, like now, is to have the matter heard. It's not bail. I just, my Lord, had my senior colleague for the applicants question the status of the respondent on the hearing of this matter. The office of the DTP does not consist cases. It is the judiciary. He has committed other offenses where he has been admitted on bail. I refer to paragraph 18. Paragraph 18 of Detective Inspector Mundakwe, Senior Festival. In respect to the first applicant. My Lord, the first applicant committed the current charges he's facing under Nakawa Court Criminal Case Number 0008 of 2025, while on bail. While on bail, Vite, Uganda Road Criminal Case Number 624 of 2023. 624 of 2023, where he was charged alongside Mr. Walter Samuel